Hello friends, in the series on the income tax cases, today we will discuss a case when a notice is issued to the assessee beyond 3 years and the alleged income escaping assessment of the assessee is below 50 lakhs. When these type of notices are issued and the assessee submits its submissions, then it is a very common practice on the part of the revenue authorities that even if assessee giving all the evidences like sale deed and the assessee share in the profit or the assessee share in the consideration, when it is below 50 lakhs, the department go ahead with issuing the notices under section 148, and in many cases, or you can say in almost all cases, they do also complete the assessment in a very ruthless and inhuman manner. What should be done in these type of cases? This case throws light on the rights of the assessee, that the assessee can file a writ petition in the High Court. This matter has been taken by Honorable Jharkhand High Court in the case of Ratan versus Principal Commissioner of Income Tax and another. This case has been reported in 467 ITR at page number 288 and the date of the judgment is 24th January 2024. Friends, the facts of the case are like this. In this case, the assessment year is related to assessment year 16-17 and the assessee has not filed its return of income. During the year, the assessee has sold a property which was inherited by the assessee along with his brother with equal share, and the share of the assessee was below 50 lakhs. The sale consideration was below 50 lakhs. The biggest mistake of the assessee was that the assessee has not filed the return of income. When the properties are sold, even if the assessee is not earning any profit or the assessee is earning loss, it is my humble suggestion that the assessee should file the return of income so that he can get rid of unnecessary notices issued under section 148. Since the assessee has not filed the return of income and the revenue was having the information that the assessee has sold the property, so they issued the notice under section 148A clause B after making inquiry. The assessee, in response to the notice, submitted all the evidences that his share of profit was below 50 lakh. It may happen that the assessee income is taxable because the share in the sale consideration was below 50 lakhs. So it may happen that the cost of acquisition is very less and there may be some profit. But since the revenue cannot issue the notice under section 148 beyond 3 years until and unless the income escaping assessment of the assessee is 50 lakh or more. Since the sale consideration was below 50 lakh, so in any case, the income escaping assessment or the income escaping cannot be 50 lakh or more. So the assessee was taking the plea that since his share is less than 50 lakhs, so this notice is barred by limitation according to section 149 subsection 1 clause B. But the assessing officer, without considering the submissions of the assessee or finding the submissions of the assessee as untenable, passed the order under section 148A clause D and issued the notice under section 148. If the assessee will choose the regular procedure, then there are every possibility that even in the assessment proceedings, this view will not be accepted by the revenue that this notice was barred by limitation and the revenue can go ahead with making the assessment. And after that, the assessee has to stand in queue for the CIT appeal for a number of years. But in this case, the assessee choose to go to the writ court and the court said that in the present case, the notice under section 148 has been issued to the assessee without considering the submissions of the assessee, which is against the principles of natural justice and rule of fairness So in the present case, the Jharkhand High Court quashed the notice issued under section 148 as found by the Jharkhand High Court not complying with the provisions of section 149 subsection 1 clause B, because the income escaping assessment was below 50 lakhs and notice has been issued after 3 years. So the notice was completely quashed and it was not a matter of remand back. At the end of this video, once again I am repeating the name of the case. The name of the case is Ratan versus Principal Commissioner of Income Tax and another, and this case has been reported in 467 ITR at page number 288, and the matter has been decided on 24th January 2024. Thank you, friends.